This is the Edge 105.1, 105.3, 5:30 is the time if you're setting your watch, setting your clock. And we are inside the legal landscape. I love this feature, Pat. We're looking at benefit or burden, understanding easements today. You know, with the boom in property development in Jamaica over the last few years, it is important for developers, for potential purchasers, and adjoining property owners to fully investigate and understand their rights in relation to property. I'm sure this should cover you listening right now. Now, one category of property rights is known as easements. It may grant a benefit or impose a burden on the land in which you have or intend to have an interest. So, what are easements? And how can they affect you as a property developer, as a purchaser, or even a regular homeowner? To assist us in addressing these questions, our guest today is Mrs. Julianne Mais Cox, a partner at DunnCox Attorneys at Law. Good afternoon and welcome to the Edge and Home Run. Thank you for joining us.
Good afternoon, Deon. It's a pleasure joining you on the legal landscape. And good afternoon also to all your listeners.
Good afternoon to on their behalf. Julianne, what is an easement? Let's start off there so we're all on the same page.
Yes, a good place to start, Deon. Well, Deon, a valid easement is a property right, typically for someone who is neither the owner nor a tenant, to enter and do some act on land that is owned or occupied by somebody else. So an owner of land grants an easement for his or her land to be used in some specific way for the benefit of another piece of land that might be beside it or close by. And I would add that there are many types of easements, Deon. A few examples are a right to walk or drive across someone's land to reach a beach or a car park, or to lay pipes under someone's land to gain access to a water supply. There is even an easement of support, which could prevent your neighbor from demolishing a wall, for instance, on his or her land, where that wall supports a structure on your land.
Well, that's a great description. And just thinking about it, now I need to ask you, my listeners, after listening to what is an easement being described by our guest, Mrs. Julianne Mais Cox, who is a partner at DunnCox Attorneys at Law, if you have any questions on the topic, then please WhatsApp our WhatsApp line, 876-383-1166. And you may call us in the studio as well at 876-906-9559. So the easement, you've told us what is an easement, Julianne. What is not an easement?
Good question, yeah. Easements are, of course, one way to gain non-exclusive rights over someone else's land. Others include restrictive covenants. You may have heard of these in the press lately. For instance, a restriction on your land title that prevents you from erecting a business complex in a housing community, or an agreement called a license. An episode of this program earlier this year looked at restrictive covenants. Well, I like to think of easements, restrictive covenants, and contractual licenses as the rungs of a ladder, with licenses at the bottom and easements as the most valuable at the top. If one was to compare easements against contractual licenses and restrictive covenants, for instance, with easements, if, for example, someone uses your land as a walking path for a long enough period, a valid easement may be created. And once created, an easement is a property right that cannot be changed or revoked by the property owner alone. It's enforceable against the world beyond permanently. Oh. What that means is that unless the easement is extinguished in very specific ways, no third party anywhere can interfere with the easement. On the other hand, a license really grants a personal right to do something on someone's land, and it will be enforceable between the parties to that license. And it can be revoked by the person who granted it as the circumstances require, depending on what the parties have agreed. Mm-hmm. And so I like to think of a license as personal permission to enter someone's land and not a property right to actually use the land. Quickly, with respect to restrictive covenants, unlike an easement, a restrictive covenant cannot be created by merely using someone's land for a long enough period. There are really contractual limitations or restrictions that are primarily, you can enforce them between the contracting parties, and only if certain tests are satisfied can restrictive covenants be enforceable against future owners, what we call running with the land. So think of a restrictive covenant as a limitation placed on how you can use your own land, while an easement usually grants someone else the right to use your land in some way.
Mm. So can you break it down? Is there any list you can give us to tell us the requirements for a valid easement?
But there are really 4 requirements or key requirements for an easement to exist. And I think the best way to explain it is by a scenario. Imagine, for example, Mrs. Smith, who owns a farm in Clarendon that has 2 routes, and she has 2 routes to get to the main road. One route runs up and down a steep hill, which is on her land, and the other runs through some fields owned by her neighbor, Mr. Campbell. It's easier for Mrs. Smith to use Mr. Campbell's land to get to the road, and Mr. Campbell is willing to permit that access to Mrs. Smith for a fee. Now, in that scenario, all the characteristics to create a valid easement of way or a right of way exist. One, just to highlight them, Mrs. Smith's farm is what we call the dominant land because it's the one that benefits from the easement, in this case, a right of way. Mr. Campbell's land bears the burden of the easement, and so we call it the servient land. So for a valid easement, the first requirement is you must have both dominant and servient land. We refer to those in law as dominant and servient tenements. Secondly, the right of way accommodates Mrs. Smith's land, meaning it has a direct natural connection to the land. For it, the land's better use and enjoyment. It is not for or only for Mrs. Smith's personal benefit. Thirdly, the lands are adjacent to each other. They're owned by different people, and the right of way doesn't require Mr. Campbell, as a servient landowner, to spend any money. And lastly, the right of way is capable of being granted. Mrs. Smith, what do I mean by that? It's not vague or uncertain. It can be reasonably defined. So, for instance, a right to a beautiful view, for instance, would be too vague to be an easement. And the right would be exercised in a specific area of Mr. Campbell's land because we wouldn't want to deprive him of his possession, use, and enjoyment of his own land. And the easement shouldn't overtake or overrun the land. Those are essentially the requirements, Deon.
Wow. All right. So you're listening, I'm listening with keen interest for easements. And I know you're going to want me to ask, how can an easement be created?
Well, Deon, there are actually a number of ways. And I'll give you some of them, the main ones. One, an easement can be expressly granted or reserved. That just simply means that it's in writing. So the owner of the servient land can grant an easement by a document called a deed, or when selling part of his or her land, a vendor can reserve an easement or grant an easement in the contract document. Secondly, what they call by implied grant. An implied easement may arise where, for example, you purchase land that is completely surrounded by land that's retained by a vendor, and your only access to get out of your land, this landlocked land, is through the vendor's land. That an easement may be implied in those circumstances and is referred to as an easement of necessity. Also by statute, to give an example of one, in all the strata developments of apartments and townhouses under the Registration Strata Titles Act, certain easements by statute are implied, such as the passage and provision of water and electricity and drainage and the sewage through all those pipes and ducts and cables and wires that are running across the development. And lastly, a very interesting one, is by long use, what we call by prescription. So an easement may arise where someone has been using another person's land in a particular way, continuously, openly, without force, and without the landowner's permission for at least 20 years. So walking on a path over someone's land for 20 years without interruption may entitle you to an enforceable property right to do so. I just wanted to end on this point, Deon, to say that it is therefore important that a purchaser doing his or her due diligence not only looks for easements that are registered on your title, but also looks for evidence of easements on the ground so that those can be further investigated. So, for example, look to see if there's a footpath visible across the land.
Really key points for if you're purchasing land or if you own land already, and for how we live with each other today in Jamaica. We realize that once we're purchasing land, you have to look and see, is there an easement for anyone else, or a case where someone may need to come to you for an easement as well too. Is that correct?
Absolutely. Works both ways. One gives and one bears the burden and one has the benefit.
Yes. Well, Mrs. Mais Cox, any hashtag did you know info for us before you leave us?
Yes, I thought maybe your listeners might be interested to know that access to light and air are capable of creating easements, and therefore property rights that a court can enforce if they're obstructed. So a right to light might prevent a developer from putting up an apartment building on his or her land in such a way that the building will obstruct the light coming through a particular window of a neighbor's home.
I'm just dumbstruck.
Yes,
you know?
Right. And also by long use. I mean, access to light and air through a defined opening, for instance, may become an easement by long enough actual enjoyment, the method called prescription, which we discussed earlier.
Thank you so very much. We learn so much every week in this segment, the legal landscape, and you've explained it so well for us. Julianne Mais Cox is a partner at DunnCox Attorneys at Law. This has been the legal landscape. Julianne, thank you so much for joining us today on The Edge.
It's been a pleasure, Deon. It's been a pleasure.
Take care now. Take care.
You too.
Bye now. All right, who will we have next week and what are we going to be discussing? It is just The Edge, 105.1, 105.3. You never know what you're going to get, but you know it this way. You do get your life. This is your life. And of course, it is your music station.